2 hours ago, a document was delivered simultaneously to the White House, the United States Trade Representative's Office, and the International Court of Justice in The Hague. It was not a diplomatic protest. It was not a position paper. It was an invoice. 41 pages, line items, legal citations. A total at the bottom that stopped every financial analyst who saw it cold. $3.5 trillion. Canada is billing the United States for economic damages incurred as a direct result of what a consortium of 40 international trade law firms has formally classified as systematic USMCA violations committed by the American government over the preceding 18 months. The filing is not symbolic. It is not a negotiating tactic dressed up in legal language. It is a fully constructed international arbitration claim, built over 14 months by the most expensive and experienced trade law assembly Canada has ever commissioned, and it has been filed in every jurisdiction where it can be enforced. Mark Carney did not announce this with anger. He announced it the way a central banker announces a rate decision, with numbers, with precision, and with the quiet certainty of someone who has already done the math and knows exactly what the math says. This is the move that Washington had no category for. The invoice rests on 3 legal foundations, each one independently sufficient to sustain a significant arbitration award. Together, they construct an argument that American trade lawyers have already begun describing, in private and with notable discomfort, as genuinely difficult to defeat. The first foundation, systematic tariff violations under USMCA. Chapter 32. Every tariff the United States has imposed on Canadian goods since January of last year has been applied without the dispute resolution process that Chapter 32 mandates before unilateral measures can take effect. The United States did not file. The United States did not wait for panel deliberation. The United States imposed tariffs by executive order and treated the legal architecture of a treaty it had itself negotiated as optional. Canada's legal team has documented every single instance. The count is 847 separate tariff actions. Each one is a discrete treaty violation. Each one carries calculable damages. The legal team calculated them. All 847. The second foundation, expropriation of contractual expectations under the investment protection provisions of USMCA, Chapter 14. American companies operating in Canada signed contracts, made capital commitments, and structured business operations on the basis of a treaty framework that guaranteed regulatory stability. When the White House began issuing directives that unilaterally altered the conditions of those contracts, not through legislation, not through treaty amendment, but through executive order, it triggered the investment protection provisions that both governments signed in 2020. The damages calculation here is not based on what Canada lost. It is based on what Canadian and allied investors lost because American executives decided treaty obligations were subordinate to political convenience. That number alone approaches $800 billion. The third foundation is the one that made Washington go quiet. It is the one that Carney's legal team spent the most time on, and it is the one that has no clean American counter-argument. Canada is claiming systemic damages under the principle of legitimate expectations, the established international law doctrine holding that a sovereign trading partner has the right to rely on treaty commitments as the basis for long-term economic planning. Canada built its export infrastructure, its supply chain investments, its energy development programs, and its labor market in substantial part around the assumption that the USMCA framework would be honored. The disruption to those plans, the redirected pipelines, the renegotiated contracts, the supply chain restructuring forced by American unilateralism, carries a price. Canada has now presented that price, formally, with receipts. But this is where the filing becomes something more than a legal document. The White House expected, if it thought about this scenario at all, that a legal filing would be met with a counterfiling, that arbitration would drag on for years, and that in the meantime the economic pressure Washington was applying would do its work. Legal proceedings move slowly. Trade pressure moves fast. That was the assumption. Carney understood that assumption, and he built the filing specifically to break it. 58 minutes after the invoice was delivered, Carney stood at a podium in Ottawa with 3 people beside him that Washington had not anticipated at all. The lead partner of the largest trade arbitration firm in Europe, the former chief legal officer of the World Trade Organization, and the sitting president of the International Chamber of Commerce's Arbitration Division. These were not government officials. These were the people who run the machinery of international commercial law, and they were standing next to the Canadian Prime Minister to make a single point visible to every government and every corporation watching. This claim is not going to disappear into a procedural queue. It has been constructed by the people who built the queue. Carney spoke for 11 minutes. He opened with a statement that has already been reprinted in the financial press of 14 countries. The United States has spent 18 months treating a treaty as a suggestion. Canada has spent 18 months documenting every instance. The documentation is now complete. The bill has been presented. And unlike the obligations Washington has been ignoring, this one comes with enforcement mechanisms that do not require American cooperation to activate. Then he announced the 4 instruments through which the invoice would be enforced, and each one revealed a layer of preparation that the White House had not known existed. The first enforcement instrument, Canada has secured pre-judgment asset identification orders in 4 jurisdictions: the United Kingdom, France, Germany, and the Netherlands. These orders do not freeze American assets yet. They identify them. They create a legal map of American government and quasi-government holdings in allied financial systems that can be moved against the moment an arbitration panel issues a preliminary ruling. Canada is not waiting for a final judgment to begin enforcement. It is building the enforcement architecture in parallel with the arbitration itself. The second enforcement instrument, 14 American states have significant trade relationships with Canadian provinces, formalized through sub-federal agreements that exist independently of the federal USMCA framework. Canada's legal team has filed preservation orders in 7 of those states, preventing the federal government from altering the terms of those agreements without state legislative consent. This converts what Washington views as a bilateral federal dispute into a multi-jurisdictional legal landscape that the White House cannot manage from a single room. State attorneys general in Michigan, New York, and Minnesota have already been formally notified. Then came the move that no one in Washington's legal team had modeled. The third enforcement instrument, Canada has engaged the governments of France, Germany, and the Netherlands, all jurisdictions where pre-judgment identification orders are now active, to designate the arbitration claim as a matter of allied commercial interest. This designation does not change the legal outcome of the claim. What it changes is the political cost of American noncompliance. If an arbitration panel rules in Canada's favor and the United States refuses to honor the award, it will not be refusing a bilateral obligation. It will be refusing an obligation that 3 major European governments have formally endorsed as legitimate. The cost of non-compliance just became a transatlantic political problem, not a bilateral one. The fourth enforcement instrument is the one that Wall Street is still processing. Canada has notified the major American credit rating agencies, Moody's, S&P Global, and Fitch, that the arbitration claim constitutes a contingent liability of the United States government that is material to sovereign credit assessment. Canada is not asking the rating agencies to act. It is fulfilling its legal obligation to disclose a material financial claim against a sovereign entity to the institutions whose job it is to evaluate that entity's creditworthiness. What those institutions do with that disclosure is their own professional and regulatory responsibility. Moody's issued a statement within 90 minutes confirming receipt of the notification and announcing a review of American sovereign credit conditions. The words review and American sovereign credit appearing in the same sentence for the first time since the 2011 debt ceiling crisis did something to bond markets that no diplomatic statement could have achieved. The market reaction was not a crash. It was something more precise and more durable than a crash. It was a repricing. American Treasury yields moved on the contingent liability disclosure. Not dramatically, the movement was measured in basis points, not percentage points, but in the direction that signals reduced confidence in American fiscal predictability. The dollar weakened against the euro and the pound within 20 minutes of the Moody's statement, not because traders believed Canada would collect $3.5 trillion, but because the architecture of the claim demonstrated something about American institutional reliability that markets had been quietly discounting for months and were now pricing explicitly. Currency traders understand something that political strategists sometimes forget: the value of a reserve. Currency is not backed by military power or economic size alone. It is backed by the credibility of the institutional framework within which that currency operates. When a G7 ally constructs a $3.5 trillion legal claim documenting systematic violations of a treaty the United States itself negotiated, ratified, and publicly championed, and when that claim is endorsed by the people who run the machinery of international commercial law, the credibility question becomes impossible to price away. The American business community's response arrived before the markets closed, and it was unambiguous in its alarm. The Business Roundtable, whose membership represents companies with a combined market capitalization exceeding $10 trillion, issued a statement calling for immediate executive engagement with Canada's legal team. The United States Chamber of Commerce described the contingent liability notification as an unprecedented development in American trade relations that demands immediate and serious response. J.P. Morgan's sovereign credit team published a client note within hours, analyzing the potential balance sheet implications of a partial arbitration award, not the full $3.5 trillion, but even a 10% partial award represents a $350 billion liability that no budget process has accounted for. Goldman Sachs went further. Its global macro research team published an analysis arguing that the structural significance of the filing was not the dollar amount, but the legal methodology. Canada had built a claim that could be partially sustained even if the headline number was dramatically reduced in arbitration. A $200 billion award, less than 6% of the claim, would still represent the largest successful trade arbitration in the history of international commercial law. And the evidentiary record Canada has assembled, 847 documented violations with calculable damages attached to each one, makes a zero outcome the least likely result in the range of possible arbitration outcomes. Wall Street was not panicking about $3.5 trillion. Wall Street was recalibrating around the realization that the floor on this claim is not zero. Republican voices in Congress did not hold their response for coordination with the White House. 3 chairs of Senate committees with jurisdiction over trade and finance issued statements within hours that ranged from concerned to openly critical. The senior Republican on the Senate Finance Committee, the committee with oversight of American trade agreements, described the filing as a foreseeable consequence of an approach to treaty obligations that this committee has raised concerns about on multiple occasions. That is a senior Republican senator on the record, telling his own president, "We told you this would happen." The international response built with a momentum that Washington could not interrupt. The European Commission issued a formal statement acknowledging Canada's arbitration filing and describing the legal methodology as consistent with established international trade law principles. This was not a statement of political support. It was something more operationally significant, a recognition by the world's largest trade bloc that Canada's legal framework is sound. In arbitration, the opinion of the European Commission on the validity of a legal methodology is the kind of third-party endorsement that panels notice. The WTO's dispute settlement body issued a procedural notice acknowledging the filing's intersection with several pending WTO proceedings involving American trade measures. Germany's economics minister described the filing as a legitimate exercise of treaty rights that deserves full consideration through proper international channels. Australia, which had aligned with Canada in 2 previous confrontations with Washington over this period, expressed support for the arbitration process and offered to provide expert testimony on the systemic nature of the tariff violations documented in the claim. The architecture Carney had been building for 14 months was now fully visible. and it was larger than Washington had imagined possible. So where does this go? The White House has three paths, and the mathematics of each one has already been done, by Canada's legal team, by Wall Street's analysts, and by every allied government that spent the morning reading 41 pages of the most precisely constructed trade law argument assembled in the post-USMCA era. Enforcement through resistance means watching a $3.5 trillion contingent liability sit on American sovereign credit assessments while arbitration proceeds, a process that typically takes 2 to 4 years and cannot be accelerated by executive order. Every budget negotiation, every debt ceiling debate, every Treasury auction during that period will occur in the shadow of an unresolved legal claim that 3 European governments have formally endorsed as legitimate. Settlement means negotiating with a counterparty that has already demonstrated it spent 14 months preparing for this exact moment, has pre-judgment identification orders active in 4 jurisdictions, has rating agency notifications filed, and has 3 of the world's most experienced trade arbitration practitioners standing next to its prime minister. The settlement number that Canada would accept is not Washington's to set. Capitulation, simply reversing the tariff measures and hoping the claim is withdrawn, runs into the problem that Carney's legal team has already filed and that 4 jurisdictions have already received preservation and identification orders. The legal architecture does not disappear because the political trigger is removed. It has to be formally withdrawn. And formal withdrawal requires the kind of acknowledgement of wrongdoing that no administration voluntarily puts in writing. 2 hours ago, the White House thought its leverage over Canada was economic. Apply enough pressure and the mathematics of dependency would force Ottawa to the table on Washington's terms. 2 hours later, the mathematics have been inverted. Canada has not come to Washington's table. Canada has sent Washington a bill, and the bill was prepared by the people who wrote the rules that determine whether it gets paid. Mark Carney ran the Bank of Canada through a financial crisis. He ran the Bank of England through Brexit. He understands, with a precision that very few people in any government possess, how institutional credibility is built, how it is lost, and what it costs when it is gone. Washington treated a treaty as a suggestion. Carney turned that suggestion into 41 pages, 847 line items, and a number at the bottom that the entire world is now reading. $3.5 trillion, legally airtight, already filed, and the clock is running.